Thanks, everybody. Welcome to, this is our 13th and final webinar of this year's Labor and Employment webinar series. We'll be talking about the Biden administration and recapping the last year and end with a little bit of forward thinking, what we anticipate we'll see going forward. Thank you for joining us, and we'll go ahead and get started. I am Kara Maciel. I am chair of our firm's Labor and Employment Practice Group. I represent employers across all industries on a variety of issues, both defending employers in litigation at the federal and state level, as well as counseling employers on compliance with federal and state laws. And then also, to the extent that that the workplace is unionized, I advise unionized and both non-unionized workplaces under the National Labor Relations Act. Joining me is my partner, Aaron Gelb.
Hello, everyone. Also a pleasure to be here and have an opportunity to speak with everyone. I divide my practice. I'm based in Chicago, lead the Midwest OSHA practice for the firm, and I'm also a long time, I think about 27 years now, management side employment lawyer, litigator, defend employers in a variety of charges of discrimination across agencies and states, cities, and the federal EEOC, and counsel employers through all sorts of employment issues.
So with that, Aaron and I are going to talk about our agenda today. I'm going to start covering the Supreme Court of the United States case review. There were a lot of really interesting cases that the court heard this past term, as well as several cases that's on its docket that could be impactful for employers. Then Aaron and I will talk about the administration's Department of Labor regulatory agenda, what we've seen both at the Wage and Hour Division as well as OSHA. And then we'll also talk about various leadership issues and priorities at the other federal agencies, including the National Labor Relations Board and the EEOC. And then finally, Aaron and I will close with just what we anticipate seeing in years 3 and 4 of the Biden administration. So with that, I'll jump right into a SCOTUS case review. Earlier this year, January 13th, the Supreme Court issued 2 decisions over similar issues that came out on 2 opposite ends of the spectrum. So in the first case, we had Biden versus Missouri, and this is where this has involved the vaccine mandate that was issued by the Secretary of Health and Human Services covering staff at federally funded health facilities. And the Secretary had issued a vaccine mandate justifying this rule by finding that unvaccinated workers posed a serious threat to the health and safety of patients, most of whom were elderly, disabled, or in poor health conditions. The Supreme Court, the lower courts had challenged the rule, and 2 federal district courts had enjoined it and issued an injunction. The Supreme Court reviewed those district courts directly, expedited briefing, and heard oral argument January 7th, and then less than a week later, issued a ruling finding that the vaccine mandate for healthcare staff could take effect, and finding that the rule fit within the statutory language, authorizing the Secretary to enact rules that he finds necessary in the interest of health and safety of individuals who are furnished federal services. The Secretary's finding that COVID-19 posed a threat to the health and safety of patients, and that vaccine reduced the threat, brought the rule within that authority. Conversely, on the same day, in a case brought by the National Federation of Independent Businesses versus the Department of Labor, the same Supreme Court reviewed the question of whether OSHA, the federal agency, Occupational Safety and Health Administration, exceeded its authority in promulgating a rule that mandated that employers with 100 or more employees required covered workers to receive the COVID vaccine or wear a mask and be subject to weekly testing. And in that decision, the court stayed the OSHA rule and said that Congress created OSHA to set workplace safety standards, and that the challenged rule went beyond that and effectively was too broad of a public health measure. The court went on to say that it was the state's role and Congress, not OSHA, that has the authority to decide how to respond to the pandemic. So I know that brought a lot of confusion to employers that were preparing for the vaccine mandate earlier in the year. And it's just an interesting, I think, indication of how similar rules can be decided differently by the same justices. A second case that came before the court this year was involving religion in the workplace. Kennedy versus Bremerton School District. Joseph Kennedy was a high school football coach, and he engaged in a number of prayer with his students during and after school games. The school district asked him to stop that practice in order to protect the school district from potential liability, constitutional liability under the Establishment Clause. He sued the school district for violating his rights under the First Amendment and under Title VII of the Civil Rights Act. The district court held that the school suspended him solely because of the risk of constitutional liability associated with his religious conduct, and therefore its actions were justified. He appealed, and the Ninth Circuit Court of Appeals affirmed that. So the Supreme Court took on the question is whether a public school employee's prayer during school sports activities is protected speech. And if so, can the public school employer prohibit it to avoid violating the Establishment Clause? The district court, the Supreme Court overturned the lower court's decisions and said that by restricting his actions because of their religious character, they burdened his right to free exercise, and felt that also the timing and circumstances of Coach Kennedy's prayers, both during the post-game period when coaches were able to attend briefly to personal matters and students were doing other things, confirmed that he didn't offer his prayers while acting within the scope of his duties. So they felt that there was no conflict of interest, and ultimately that his suspension violated his First Amendment and civil rights. A couple of other interesting cases that are on the docket for this coming term. The first one is Glacier Northwest versus International Brotherhood of Teamsters. This involves a unionized facility that had its employees locked in a contract negotiation. The contract expired and the employees went on strike. The employees worked at a ready-mix concrete company and were drivers loading and unloading concrete. And when they went on strike, the drivers brought the trucks back to the facility and left them. Some notified the company, some didn't, some left the trucks on, some didn't. And ultimately, the company had to dispose of the undelivered concrete to avoid damage caused by the hardening concrete. The company disciplined the drivers and then sued the union specifically for the costs associated over the wasted concrete. The union filed an unfair labor practice charge against the company and ultimately sued. The Washington Supreme Court held that the company's suit against the union for economic costs could not proceed because the National Labor Relations Act was preempted and prohibits rules of these kinds of lawsuits brought because of economic losses stemming from either union activity or picketing or strike activity. So the Supreme Court has taken this question up as to whether the National Labor Relations Act preempts the ability of individuals or companies to sue each other for economic damages associated with union activity. The second case is Helix Energy Solutions versus Hewitt. This involves the FLSA's exemption for highly compensated individuals. Michael Hewitt, he worked as an offshore rigging managing other employees, and he was paid, however, on a daily rate. And because he was paid on a daily rate and he worked offshore, he often worked over 40 hours in a work week. He sued his company for overtime pay under the FLSA, and the company responded that it's not required to pay him overtime because he was a highly compensated individual making well over $200,000 annually. So the question before the Supreme Court is whether the Fair Labor Standard Act, is a supervisor who's compensated highly, whether he's entitled to overtime pay, despite that he is calculated on a daily basis. And then the third case that I think is going to be pretty interesting for employers is the Students for Fair Admissions versus the University of North Carolina. And what this involves is the issue of affirmative action in college admissions. So the Students of Fair Admissions sued the University of North Carolina because of its process by using race as a factor in its admissions. The university admits that it uses race as one of many factors in its admission process, but is arguing that the process adheres to the requirements for race-based admissions outlined in another Supreme Court precedent. After a trial, the district court ruled that the university's policies were permissible under constitutional scrutiny, and the Fourth Circuit affirmed. And so right now the question is, may institutions of higher education use race as a factor in admissions? And if so, does the university's admissions process violate the 14th Amendment to the Constitution? During oral arguments, Justice Kagan raised the issue of whether employers outside of the higher education system may consider the benefits of diversity, race when making hiring decisions. And so this case could have, and she indicated it could have potential implications in employment, including any voluntary diversity, equity, inclusive measures, even under federal executive orders, or through state diversity quotas, such as California's SB 826. It could increase a reverse discrimination claim, and it could lead to a decrease of diverse applicants if you cannot take race into consideration when making hiring decisions. So I'm sure we'll hear a lot more about this, the University of North Carolina case, when that decision comes out. And with that, we'll turn over to the Biden administration's, the Department of Labor regulatory agenda. I'll start with the Wage and Hour Division. Couple of little interesting things happening there. We've got the nominee, Jessica Lumen. Her nomination been pending in the Senate for a while, not with a lot of activity, but just last week, her nomination passed the Senate Health Committee and will now move to the full Senate for a vote. We'll see where that lays now that we know after last night's election that the full Senate is 51 Democratic. So more likely than not, her nomination will proceed through the Senate. Two other regulatory issues are being considered by the Wage and Hour Division. One is this issue of whether to update whether a worker is an employee versus an independent contractor. And for those of you that have participated in many of our webinars over the last several years, we almost always talk about this because the rules and the agency has flipped back and forth several times over what is the appropriate test for the independent contractor. Right now, the Biden's administration proposed rule would restore the totality of the circumstances analysis of the economic realities test. That version of the test has been subject to legal challenge several times, started out in the Obama administration, then it was flipped in the Trump administration. It's gone back and forth, as you can imagine. Public comment period ended last month, a couple days ago on November 28th. So we'll see what happens, but we do probably expect the administration to finalize the rule, which will limit when a worker may be properly classified as an independent contractor. And if if past history is any indication, we would probably likely see legal action filed by a number of other business groups that sought legal action during the Obama administration. The second regulation is, we hear that the Wage and Hour Division is reviewing overtime, but hasn't really made clear whether and what types of changes it's considering, whether it's considering increasing the minimum base salary for purposes of qualifying to be exempt from overtime, or if they're looking at modifying any of the primary duties tests for each of the exemptions. They have held listening sessions over the last year, and we'll see where they go going forward. Their last revision to the regulation as you may recall, did increase the salary threshold. That's more likely where they will go again over the changes to the primary duties test, but we'll see. So with that, I'll turn it over to Aaron to talk about what's happening at OSHA.
Thanks, Kara. And there has been quite a lot going on, really two themes, enforcement and rulemaking. So I'll talk about the rulemaking now, and then I'll get into enforcement towards the end of the webinar today. The first year and a half of the agency's rulemaking agenda was, as you might imagine, heavily focused and almost exclusively focused on COVID. Kara talked about the failed effort to institute or pass the emergency temporary standard that applied to general industry for COVID-19. OSHA did promulgate a separate emergency temporary standard for healthcare that did remain in place for 6 months. And I'll talk a little bit about the what's going on with that permanent COVID rule in a minute. But now that COVID is, at least has been, fading away somewhat, we're all reading about I think I saw one news source describe it as the triple-demic because of the flu, RSV, and COVID. So who knows what's going to happen, but President Biden has declared COVID to be over. OSHA, except for in healthcare, really seems to be treating it like it's over. The agency last updated its general industries guidance back in August of 2021, and despite repeated promises to update it, we have not seen that. So I think certainly for the next 2 years that we expect the agency to aggressively turn its attention to rulemaking of traditional safety and health standards. We've seen them get started in an area that it was not surprising, given that the head of OSHA, Assistant Secretary of Labor for Occupational Safety and Health, Doug Parker, came from Cal OSHA, where he ran that agency, and really the centerpiece of rulemaking efforts in California at Cal OSHA was the development of a heat illness rule. So it really came as no surprise, and this is something that OSHA has been talking about and wanting to do for a while. So I think Doug was probably the perfect person to do that, having shepherded a similar rule through in California. So for those of you that are rulemaking nerds, which are special, we're all safety and labor and employment nerds here, but rulemaking nerds kind of take that to a whole nother level because it's such a complicated and can be such a long process. So this slide just summarizes basically where we've been for the past little over a year. So OSHA issued its ANPRM, Advanced Notice of Proposed Rulemaking, back in October of 2021. We at ConMaciel formed a coalition of employers that intend to participate in the rulemaking process. As part of that coalition, we submitted comments at the beginning of this year. And then since then, NACOSH, which has created some working groups, and those groups have had meetings. We participated in those. Then there was a public stakeholder meeting that took place in May. The working groups have continued in September, continued this fall in September. And like I said, this is the beginning of the process. It's for those of you that follow it, you know, they can take years and years. So I'm reluctant to even try to predict when we will see a permanent rule published. At this point, I certainly don't expect to see that in the next 2 years. And then, of course, if the White House changes hands in 2024, this rulemaking could very well be stalled and put in mothballs for a period of time. So moving on to the next slide, just looking at based on the signals and some of the comments that we've seen and information that we've gleaned from OSHA, there's a lot of balls in the air, or things that could potentially be included in a permanent rule for heat illness. Some of them are probably pretty straightforward and standard, the sorts of things that employers expect to see in a rule like this, and others could be more problematic. So one thing, just for those of you that are listening, you're like, well, we have indoor workplaces where, we're not construction sites or roofing companies or what have you. This rule will apply to indoor and outdoor workplaces. So factories and other warehouses and places that get warm will indeed be covered. So some of the things that certainly are likely to be included in a rule would be the requirement to have a written heat illness prevention program. There are other things like training, having an emergency response plan. But then when we look at things possibly like acclimatization requirements, so that is in essence kind of helping your employees and get used to working in warm environments. Sometimes those acclimatization requirements can be very prescriptive and lay out periods of time and amounts of work that people can do. Something like that really can be a challenge for industry if it limits the work that people can do and for a period of time. Others described like some of the hydration requirements is turning employers into the water police, where it's not just that you have to give people an opportunity to hydrate, but that you have to require them to hydrate. And there are a host of other things that we'll be watching. Again, if it's something that concerns you and your business, your industry, let us know, because there's still ample time to get involved in our coalition and participate in the rulemaking process and help develop those comments that we'll be submitting. Moving on to the next slide, another piece of rulemaking that is proceeding along involves the e-record keeping rule. And just a quick recap for those of you that remember, we're now over 6 years ago, during the Obama-Biden administration, that administration published a rule that required the uploading of electronic uploading of injury and illness records. Initially, the proposal was to require it for the uploading of your 300 logs, the 301 incident reports, and the 300A summaries. There were some limits to that. Then, interestingly, and not surprisingly, that in shortly, right, partway through the Trump administration, the OSHA, and again, for those of you that probably remember, particularly if you participated in any of our OSHA webinars that we talk about quite often, that there was never a head of OSHA. There was an individual that was nominated but never went to a vote on the Senate floor, and so OSHA was essentially leaderless throughout the entirety of the Trump administration. Nonetheless, there were certainly some steps taken with respect to rulemaking, and one of which was the administration or OSHA issued an amended rule that eliminated the requirements to submit the 300 log data and the 301 data. Those were the two pieces of information that were most concerning to employers for a number of reasons. And so it was really limited to just the 300A summary data. And so if you are one of the covered employers, hopefully you've been doing that for the last few years, or at least the last 5 to 6 years, and that is still a requirement. But now moving on to the next slide, please. So what the agency, you heard Carrie talk about it, and we'll probably be talking about it again throughout this webinar, this concept of the pendulum swinging back and forth. And so now we're seeing that happen with this rule as well. So in March of this year, OSHA issued a proposed rule that would once again expand the e-record keeping requirements and really go even farther than what OSHA under President Obama had proposed. So under the key changes, this revised rule would maintain the requirement for those employers that have at least 20 employees that are in certain high hazard industries that are set forth in the proposed rule. They would submit only the 300-day summary data, but they've changed the list, expanded that list so there would be more employers covered. It would eliminate the requirement for all workplaces to submit the 300-day data, all workplaces with more than 250 employees, but then replace that so you're sensing a theme, right? It's expanding it here again. Replace that requirement with the threshold lowered to 100 employees for again expanded set of high hazard industries. And these covered employers would have to once submit the 300 logs, the 301 incident reports, and the summaries. And so when looking at the next slide, then you can see that we have a lot of concerns in our clients, employers that we work with have a lot of concerns. Thousands of more establishments would be covered, again, with 300 log data and the supporting data in the 301 incident reports. We're talking about significantly greater amount of data, data that implicates privacy concerns, right? So now not every piece of information in the 301 incident report would be required to be submitted, but certainly there is information in there that would be required that does implicate privacy concerns. Additionally, once all of this information is out there, and it could be subject to a FOIA request, it can be used by individuals, whether it's unions for organizing, whether it's attorneys seeking to bring an action against the company. So there are a lot of concerns that go into this, and so it's another one of the proposed rules or revisions to the rule that we will be tracking closely in the year ahead. All right, and then I mentioned earlier about the COVID-19 rulemaking. So kind of consistent, I think if you think back to how OSHA and the administration have really kind of lagged behind with respect to COVID, and it's not a criticism so much as a recognition of reality with a virus that moved so quickly. Government by its nature is not equipped to move as quickly or be as responsive, and so it seemed in many cases that OSHA, like other agencies, was always a step or two behind, and needing to coordinate with other entities like the CDC. I think OSHA is struggling mightily with this permanent rule that will again only apply to healthcare, just as it did with the prior rules, but particularly the general industry rule that was stayed. So originally, we expected and OSHA promised that this permanent rule would be published by September, October of this year. Obviously, that didn't happen. Nothing has been sent to OMB yet. And once it does, there'll still be time at that point for further and final review. Looking at the timeline, I think when he was testifying or speaking before Congress, Secretary of Labor Walsh estimated 3 to 6 months when he spoke on June 15th, which would take us right up about a week or so from now. Perhaps still meet that deadline. I'd be surprised. In August, the DC Court of Appeals held that it had no authority to push OSHA to move faster, which takes a little bit of the pressure off the agency. At the same time, the CDC continues to water down face covering requirements. Announced about a month or so that it was in certain jurisdictions where COVID rates are lower, that even in healthcare settings, that it would be acceptable to take off the masks or the face covering. And last but not least, President Biden, as I said earlier, had announced that the pandemic is over, which I think further complicates OSHA's job here in terms of promulgating a permanent rule. The agency remains tight-lipped. We don't have any updates or further promises as to when to expect that rule. Additionally, and I'm not a PSM expert, and I've mainly included this slide to advertise that we are going to be hosting an OSHA webinar with a very in-depth update of the process safety rule and the rulemaking process, among a number of other issues, including the Chemical Safety Board and what's going on over there. I think the key takeaway to know is that PSM rulemaking is back in full swing as well. It has passed the SBREFA phase, that's the Small Business Regulatory Enforcement Fairness Act. And then additionally, kind of moving parallel track, the EPA, once the EPA finishes its risk management program or RMP rule, which that is a rule that requires facilities that use extremely hazardous substances to develop a risk management plan. These plans need to be revised and submitted to the EPA every 5 years. Once that process is finished at EPA, we expect OSHA will move pretty quickly to adopt similar updates to the PSM rule. So if you are in that very niche subset of employers that are covered by the PSM rule, definitely tune into our webinar. I believe it's next week, but it's on our calendar as well.
Thanks, Aaron. All right, with that, let's turn over to some of the other federal agencies outside of the Department of Labor. The first one is the National Labor Relations Board. Currently, right now, as of today, we've got full complement of 5 members of the board. But as you can see, one is about to leave this month. So it's the board is chaired by Lauren McFerrin. She has chaired been on the board for many, many years and has been chairing for the last 2. She leads the board with 2 Republican members, John Ring, who was the chairman during the Trump administration, and Marvin Kaplan. Member Ring's term, as I said, expires this month, so it will leave the board with 4 members. Mr. Kaplan, Ms. Wilcox, and Mr. Prouty will all stay on through at least through Ms. Wilcox through next year, and then the others have a little bit longer term. Probably won't really substantively change the makeup of the board or the process of the board, because it'll still have a 3-to-1 Democratic majority. But that being said, it could make it a little bit easier for some of the cases to move along with Marvin Kaplan, as the sole dissenter. Some of their priorities over the next couple of years, and what we've seen this past year from Jennifer Abruzio, who's the general counsel, really changing some of the mandatory submissions to the advice. And what she really wants is, look, there are certain cases and subject matters that she wants the regions, the various regions across the country to submit to the board for advice. And that includes employer handbook rules, confidentiality provisions, what is protected and concerted activity, all with the aim to overrule prior board precedent from the Trump administration and make these cases in these subject areas more employee friendly, union friendly. So we've seen, again, this issue, and as Aaron mentioned, the NLRB is notorious for the flip-flopping back and forth. And so I know that employers struggle with feeling like they have to constantly update their employee handbook every time there's a new board, because oftentimes what happens in union organizing campaigns is one of the very first things that a union will request as part of that campaign is to review the handbook, or they'll get a copy of the handbook from the organizers. And if that handbook contains policies and that the board considers to be intrusive on Section 7 rights of the employees, they will use that as leverage in their organizing campaign to either try and stop the count from happening if they think they're going to lose, or somehow use it to bear pressure on the company to either agree to a card check or respond to an unfair labor practice charge. So those are some areas that we think that the board is interested in. Some other things that she's interested in looking at are Weingarten rights. That's the right of in unionized settings only, that an employee can ask for a witness or someone to participate in any meeting with the employer if it's going to lead to discipline. And so they're looking at maybe expanding that to all workplaces, not just unionized workplaces. Again, looking at who is an employee and who is not for purposes of coverage under the National Labor Relations Act, really trying to broaden who is an employee versus a statutory supervisor. So they'll be looking maybe at defining a little bit more and narrowing who can be a supervisor that is outside the scope of the Act's protections. The employer's duty to recognize and bargain issues of mandatory subjects of bargaining with the union is something that they're looking at. And then other things that are really traditionally submitted to advice is issues of partial lockouts, injunction, litigation matters, kind of complex subpoena issues, those in orders of priority. We're also hearing more recently, just a few months ago, that she would like to challenge current NLRB precedent that allows employers to hold mandatory meetings during organizing campaigns. Those are called captive audience meetings, and the board is looking at limiting the employer from being able to do that. I think the business community would argue that employer has the right to speak out in favor or against unionization, just as employees do, and so I could see a significant challenge to that. And then finally, a topic that many of the agencies are looking at, I think both the Department of Labor, certainly the board, and the EEOC, which I'll talk about in a little bit, is the idea of electronic monitoring, but also in particular, artificial intelligence on Section 7 rights. So how does the employer use either artificial intelligence to monitor or other type of monitoring of employees' activities? And does that somehow violate the employee's rights to engage in protected, concerted activity that is in the workplace? So those are some issues, top priorities that we'll see, and I think that will continue over the next 2 years of the administration. The other thing that we've seen that is consistent across the agencies is this idea of strengthening the interagency coordination. So the General Counsel issued a memo responding to the White House task force that issued a report on strengthening the partnership with other agencies. And she said, quote, "I agree that it's crucial for federal agencies to collaborate to increase workers' protections from systemic abuses. Stronger collaboration and networked enforcement will particularly assist those most vulnerable and will help to secure a voice at the table through union representation if workers so choose." So as a result, she signed a memorandum of understanding that established collaboration and cooperation between the board, between the Department of Labor Wage and Hour Division, and the Office of Labor Management Standards. And we're seeing that as well, as I'll talk about in a minute or two, with the EEOC on whistleblowing as well. So be aware that the agencies are talking to each other if they feel they have a case of whistleblowing or retaliation. Maybe they think it's because they engaged in protected, concerted activity that board disagrees or doesn't find enough of a causal connection between the protected activity and the adverse action, but thinks maybe it was because of some other reason, maybe it was because of a race issue or a gender issue, and will collaborate and confer with the EEOC, often then forcing employers to defend multiple charges under the same exact grounds before 3 different agencies. And we've been seeing that collaboration and cooperation increase over the last year or so. And so part of what that MOU really is establishing webinars between the Department of Labor and the EEOC that focus on retaliation. Also working together between the IRS and the Department of Justice and the FTC to address unfair method of competition. We're seeing that potentially with narrowing non-competition agreements, non-compete agreements at the federal level. Right now, we've seen that often at the state level, but the FTC has been a little bit more vocal lately about their interest in minimizing and banning non-competition agreements. Looking also with the Department of Homeland Security to ensure that all workers, regardless of their immigration status, have the full protections that they need to assert their rights, whether it's before the Department of Labor or otherwise. And then working with the Small Business Association to create a guide for employers that is working towards educating workers again about worker rights and through a broader outreach. So a lot of collaboration at the agency level, primarily designed to educate and inform and collaborate and increase workers' ability to challenge employer policies or employer decisions that could be viewed as anti-retaliatory or whistleblowing. The other thing that we're seeing come from the NLRB recently is back in September, they issued another notice of proposed rulemaking for determining what is a joint employer under the National Labor Relations Act. I think joint employer is at the same level as the flip-flopping of the independent contractor rulemaking that we've seen from the Department of Labor. This has gone back and forth as well. And so what this rule would be to reestablish the Obama era standard of joint employer to include not only what is direct or immediate exercise of control over a workforce. So if your supervisors are directly supervising another employees at your workplace, but also if you reserve or have indirect control, even if you've never exercised it. Even if you have that in your staffing agreement or in your consulting arrangement or not indirect employment agreement, subcontractor arrangement, that if that language of reserve control is in that agreement, this new rule would expand that to make your company a joint employer with your staffing company or the other actual direct employer. Public comment ended today, so we expect to see a final rule next year. Moving over to the EEOC, I'll just touch on briefly because I think I've already mentioned this, but earlier, late November, we had EEOC member Janet Dillon resigned from the commission. So now the EEOC is deadlocked with 2 Democrats and 2 Republicans. The general counsel nominee, Carla Gilbride, has passed the Help Committee and will proceed to a full Senate for a vote, which we expect will pass. And a couple of issues that EEOC is focused on, as I mentioned, the issues of artificial intelligence. The commission continues to speak about the interaction between anti-discrimination law and AI and the considerations for employers. So if you use AI in any hiring decision-making or to screen resumes or applicants or thinking about using AI, in the interview process, those are things that the EEOC is looking at to make sure that there isn't some kind of subconscious bias that is happening through those interactions. And then, as I just talked about, the increased coordination between OSHA and the NLRB to enforce the whistleblower statutes, both from the EEOC and those federal agencies, a lot of coordination to combat alleged retaliation. So retaliation continues to be a huge charge statistic on the rise before the EEOC. We've often seen people file charges of race discrimination or gender discrimination or disability discrimination, and they'll tack on a retaliation as well. And oftentimes we see that the agency finds no probable cause on the underlying reason for the action, but will find potential cause on retaliation. So really just a good reminder that employers in making any employment decisions to always consider whether a retaliation claim could be made for one reason or another. So with that, we have 15 minutes left, we'll turn to sort of predictions and what we think will be happening for the next 2 years. The election is finally over as of last night and confirmed that we've got a divided Congress in 2023, which is really going to make it difficult, I think, for the Biden administration to move any federal legislative agenda forward. I mean, we've got still a small majority, Republican majority in the House, and a small majority in the Senate. But I think without a lot of bipartisanship, we probably won't see anything happening in Congress that will get to Biden's desk for signature. And so as a result of that, we think that the administration is going to look to the federal agencies really to address its labor and employment agenda. So it's really going to rely on what I just talked about with the National Labor Relations Board and moving some of those regulatory issues ahead and reversing prior precedent and prior board case law. Similarly, we think we'll see, seeing regulation going through the wage and hour division on overtime and potentially independent contractor, the joint employer rule from the board, the issues before the EEOC. So that's really where the Biden administration is going to be able to make its case because they control the majority of the leadership within those federal agencies. And then as a result too, we think that because there's not going to be a lot happening at the federal level, it will go back down to the state and local levels. So issues that we've seen of pay transparency, New York and several other states have passed laws requiring pay transparency. So employers are going to need to modify their pay practices and disclosure practices with respect to pay. Minimum wage continues to be on the ballot across the country. We saw that occur in several states this year, as well as marijuana legalization that just passed in Maryland. It was on the ballot in other states as well. And so, what do employers do with respect to the legalization of marijuana when it's still unlawful at the federal level? So those are just a few of the issues of the employment issues that I think we might see going forward. And Aaron will speak and touch on a little bit about what he thinks will happen in OSHA.
Thanks, Kara. When I was preparing for this, I was reminded of the cinema classic Rocky III, when Clubber Lang, the boxer that was played by Mr. T, was asked about the fight with Rocky, and he said, "What's your prediction?" And he said, "Pain." So my prediction for employers dealing who are likely to deal with OSHA is essentially pain. That's more inspections, more higher fines, a greater number of citations, a greater number of percentage of citations issued as high dollar repeat citations, more public shaming through press releases, and then a significant change to OSHA's severe violator enforcement program. So I'll break that down. The statistics that we're seeing, and we'll be covering in depth a deep dive into the statistics for the past year in the OSHA webinar in January, the look back at 2022 and the look ahead at 2023. So please join us for that. But what we've seen, early returns are that inspections have returned close to pre-pandemic levels, right? So for the past 2.5+ years, certainly in the first year and a half or so of the pandemic, OSHA was barely getting out there. Or inspections plummeted to, I think, around 20,000 from in the 30s, maybe even lower. Many of those were virtual inspections. So they're back in person, getting into your workplaces. This slide is just kind of a summary of the types of inspections that OSHA can conduct. A theme that we're hearing from the Department of Labor to kind of the marching orders to OSHA are essentially use all the tools in your toolbox, which really translates into find reasons to get into workplaces, particularly those that are in high hazard industries, those that have had contact with the agency in the past, that have been inspected, particularly those that have been cited. So I've highlighted a few of the ones that I think are noteworthy. Perhaps none more so than follow-up inspections. So if you've been cited in the past couple of years, particularly if it was a hazard that is likely to reoccur, so machine guarding, lockout, tagout, forklifts, things like that, there is a good chance that the area office that did that inspection is going to send somebody out to do a follow-up inspection. I've seen more follow-up inspections in the last year this year than I can recall in the prior probably 5 years. It's an easy way to get back in there and verify that things are still the way they're supposed to be. We're seeing a higher incidence of referrals from one agency to another. So Wage and Hour is in your workplace doing an investigation, and they see something, particularly with heat illness, that is part of the heat illness emphasis program. So they may make referrals to OSHA. And then the other, there have been and probably always will be emphasis programs, both national and local emphasis programs, which means that OSHA goes in and inspects an employer based on its industry classification alone. No complaints, no injuries, no hospitalizations, but just you're in this industry, you're on this list, we're going to inspect you. It's a proactive way to get out there. And if you look on, if we can move to the next slide, we've included a list of some of the emphasis programs. So a number of these really most of the ones on this list are national emphasis programs that mean that they apply across the country in those states that are under federal OSHA jurisdiction. The heat illness is the new one. Amputations is a big one that covers a lot of employers. There are also emphasis programs for noise and dust and certain types of metals. But then we're seeing a significant, or at least certainly an increase in the local and regional emphasis programs. If you're in warehousing, there's a new emphasis program out east in Region 3. If you're a food manufacturer, there's a new emphasis program here in Region 5, which covers Wisconsin, Illinois, and Ohio. There are a host of other local and regional emphasis programs that you should look into to determine if you are covered. And I expect to see more of them in the next couple of years. These emphasis programs, again, get OSHA into your workplace. And if it's a hazard that is deemed to be or believed to be frequently occurring in your workplace, there's a good chance that you've either been inspected for or cited for this in the past. And that means that there's a good chance that you could get a repeat citation. So max penalty right now is $14,502 for serious, but up to $145,000 for a willful or a repeat citation. So if you've gotten one, and you are at risk for another, obviously the penalty can multiply by 10, which is pretty significant. And if you get multiple repeat citations, then you have the distinct pleasure of potentially being referred to the severe violator enforcement program. So if we can move to the next slide, you'll see here that OSHA just announced about, I guess, almost 3 months ago now in September, that it would be making changes to the SVAP, or severe violator enforcement program. Essentially, SVAP is what I refer to as the worst of the worst in OSHA's eyes, certainly not in reality. We've been talking about and advocating on behalf of employers for years on this issue. Employers are placed into this severe violator program when the citations issue, not when they become a final order. So upon issuance, an employer is placed into this program. They go on to a list, or a log, which is kept on OSHA's website. There is almost always, I think, always a press release about it. It has a number of very damaging implications for employers, from negative impact on the public perception of your company, recruiting efforts, customers, vendors call. They want to know if it's safe to do business with you. It leads to additional inspections at sister facilities. The list goes on, and it is very hard to get out of the program. So let's talk about how it changed. Doug Parker said that we've changed it because we want to get more employers into the program. Basically, they're pretty clear in their intent, and enforcement data shows that there would have been at least 100 more referrals to the SVAP program had these rules been in place this year. And so how have those rules changed? If we look at the next slide, then you'll see there are a couple of changes that are more probably not significant for most of you. One is that it eliminated the criterion for those that are in that process safety world. But really that's not a help to those folks that are covered, that are in that world, because the big change was that previously it was that employers would only be referred into SVAP if they received 2 or more willful or repeat citations relating to one of about 10 what are called high emphasis hazards. And they're spelled out in the SVAP directive. And as you might imagine, they are considered some of the most dangerous aspects of certain workplaces. And so what OSHA did was it eliminated that criterion, meaning it now is not limited to those 10 or so high emphasis hazards. Instead, any employer that gets 2 or more willful or repeat citations that are considered high gravity, and high gravity is simply just a characterization that OSHA comes up with in the course of the inspection based on the likelihood of harm posed by the hazard. So is it potential for death or serious injury, and essentially the likelihood that the hazard would harm an employee. probability. So high severity, high probability equals high gravity. And so there are going to be many more repeat or willful citations that will fall into the high gravity bucket as opposed to a high emphasis hazard. So it could even be things like forklift citations or material handling and storage citations, in any number of them. And so this really raises the stakes. And if you get citations now that you thought, well, we might be willing to take those, we'll roll the dice and hopefully we don't get a repeat citation. Now those stakes are higher, which makes it all the more important to fight even the serious citations now, because those serious citations can then lead to repeat citations in the future. So moving on to, and this is a quick slide that shows the overwhelming percentage, almost 70% of the employers that are referred into the SVAP program have been placed in there in the past because they received those 2 willful or repeat citations, which is now going to be the far more, even easier way to get put into that program. So then moving on to, I think the last slide, and this ties to also to the earlier comments that I was making about the e-record keeping rule, the proposed changes to the e-record keeping rule. While the administration is seeking to expand the coverage of that rule, it is also undertaking efforts to make sure that employers who are covered are submitting the rules or submitting the data that they are currently required to submit. And so what they're doing now is, through this program, is they're simply matching, when they're in an inspection, making sure that if you are covered by the rule, that you have submitted that data, uploaded it electronically. If you haven't, then that's another citation that you will most likely receive. Every year when it comes time to submit this data, I get calls from employers that are having technical problems. They weren't able to get the data uploaded. There were errors, that the gateway wasn't working. So my advice to you, if you encounter that, is keep detailed notes. Take a screenshot, snip and clip with your Microsoft. Take your phone out, snap a picture of the screen. If you speak to somebody at OSHA, get their name, write down the date, the time you spoke to them, their phone number. If you have that sort of information, you could show you made a good faith effort, but for the technical issues, I think you stand a much better chance of avoiding a citation. So I think that is the last of the slides that I wanted to cover about enforcement. So again, just to recap, if you have any concerns about your workplace safety and health programs, policies, procedures, this is the time to act proactively. Bring in a consultant, bring self-audit, do things that are likely to catch those things, because I think it's just more likely than ever that OSHA is going to be in your workplace, or certainly more likely than it was in the past 2 years.
Thanks, Aaron. So that wraps up our final webinar of our 2022 Labor and Employment webinar series. Here's a list of what we covered over the past year. If you were unable to attend any of these, they have all been recorded and are listed on our website under our webinar archives. So take advantage of that, and we'll be shortly releasing next year's webinar series. So stay tuned for that. Please continue to check out our blogs. We regularly post to that and update really timely issues that are affecting employers on the myriad of issues that our practitioners cover. And with that, I know we're right at 2, so I don't think we've got time for questions, but if you have any questions after the program, please don't hesitate to reach out to either myself or to Aaron, and we'd be happy to do that. We hope you enjoyed today's webinar. Thanks for joining us, and wishing everybody a healthy, happy end to the 2022, and see you next year.
Take care, everybody. Thank you.